Madam, may I mention one, yesterday's matter for withdrawal, madam.
Which one?
Madam, yesterday's matter, the read appeal, madam, number 03, 2024, madam.
Is it listed today?
No, madam. But just for withdrawal, madam, the subject to, madam, the availability of your lordship's time, madam. Just for withdrawal, madam.
Tomorrow? Tomorrow? Tomorrow?
No, madam, today, madam. Second half or, madam, this. Otherwise, if matter is called for, madam, it can be, madam, the
Okay,
pardon.
call for the records.
Madam. Deeply.
May I plead your worship,
Yes,
my
ma'am.
lord? I beg to mention item number 5, my lord, of supplementary hearing today's list, my lord.
Item 5.
Yes, my lord. My lord,
Yes,
matter may
yes,
be-
wait, man.
Yes, my lord.
Where's the supplementary? Oh, yes.
Okay. Yes, my lord. This matter may be taken up after 4 weeks, my lord. I've taken consent from the petitioner
Ma'am, you're the counsel for
for the respondent, my lord.
the
Government respondent. State
government
respondent,
respondent.
yes, state
Okay,
respondent.
for the state.
May I, Your Lordship?
Yes,
Your Lordship, in this case, earlier we were the counsel, Your Lordship. Now the petitioner himself, he has decided that he will take this case in person, Your Lordship. So we have given the NOC also, and then case records also we have given to the petitioner. So we humbly submit that our name may be removed from this case, Your Lordship.
you are
Jade Singh, Your Lordship.
J. Sirin.
Yes, Your Lordship.
That means Nalo Pada and Associates?
No, Your Lordship. Khoda Tama and Associates, Your Lordship.
Who?
Khoda Tama, the second.
Koda Tama and Associates.
Yes, Your Lordship. Your Lordship, from Khoda Tama to T Lampung, Your Lordship, that we are all same associates, Your Lordship.
You are J. Sirin.
Yes, Your Lordship.
Mr. J. Sirin. The learned counsel submits that he and his associates have handed over the files of the case to the petitioner who desires to appear in person himself, and accordingly seeks the permission of this court to withdraw the Wakalatnama which is filed on behalf of the petitioner. Stop. Prayer is allowed. Mr. J. Tsering and associates are allowed to withdraw the Wakalatnama filed on behalf of the petitioner. Stop. MS new para, MS so-and-so, learned,
State respondent, state,
public prosecutor,
no, my lord, government advocate.
OPIL, learned, government advocate. Six adjournment of the case for 3 weeks.
4 weeks, my lord.
3 weeks, 4 weeks, no difference. Prayer is allowed. Listed after 3 weeks.
Much obliged.
Your Lordship, I beg to mention item number 3 and 4.
3 and 4.
Yes.
Yes, yes, ma'am.
The arguing counsel is out of station, so maybe listed after 2 weeks.
Who is the arguing counsel?
Sunil Mao.
Sunil Mo.
Yes, Your Lordship. I have taken consent from the other party.
Okay, MS. When do you want it?
After 2 weeks.
Let it be
Up to-
after 3 weeks, Your Lordship. It's a criminal appeal, Your Lordship.
MS so-and-so. Learned counsel submits that. The Mr. Sunil Mo, the leading counsel in the case, is out of station
Yes, Your Lordship.
and therefore seeks adjournment of the case for 3 weeks. Queries allowed? Listed after 3 weeks.
Obliged, your lordship.
Okay, what is the matter about, ma'am?
It's extrajudicial killing. We haven't received till now the inquiry report from the respondent.
This court has ordered some inquiry.
Sorry, Your Lordship.
This court has ordered some inquiry.
Yes, yes.
Where is that order? Yes.
Inquiry report from the judicial court, your lordship, from the court, London court below, the same is received by this court. And your lordship, on 14/11/23, the registry was directed to furnish the report of the judicial inquiry to that effect, so that the petitioner or the respondent, they will file their respective affidavits.
On 14/11, okay. Petitioner has not yet submitted the Learned Counsel for the petitioner has not received the copy of the judicial inquiry report conducted pursuant to the order of this court. The Learned State Council submits that the same shall be furnished to the Learned Counsel for the petitioner within a period of 2 days from the date. Accordingly, in the meantime, but is required a response by way of the same shall be furnished. Whether the State Council has furnished?
No,
The
till
report-
now we haven't received any.
My lord, we have
Yes.
received of the inquiry report. Yes, my lord, from the registry, my lord. We
Okay,
have received the inquiry report.
from the registry.
Yes, my lord.
So who is to furnish you the copy?
The inquiry report will be provided by respondents to us, judicial inquiry
That is
report.
actually-
And they have to
So
file
now-
affidavit.
My lord, that's a
That
wrong
is
order
what the orders 14/11/2023 says.
because that inquiry report was directly submitted to the registry, my lord. It's a part of the court record.
In fact, my lord, that the report has to be, my lord, furnished by the registry. We
By
have-
the
Yes, my
registry.
lord.
But
And we have received the copy, my lord.
as per this order,
Yes, my lord.
the state respondents are directed to furnish the copy. Okay.
And my lord, we are under process for the, my lord, the filing of, the affidavit.
Correct.
In context of this, my lord, report. Basically, finding is against us, therefore, my lord, we are in a process to file, affidavit, my lord.
Very report. Even me, no? Fine, no? Inquiry report, no? The respondents you have received.
Yes, ma'am.
No, I haven't.
By way of- MS, you're the counsel for the petitioner, ma'am?
Yes.
MS so-and-so. Learned counsel for the petitioner. Submits that. She is yet to receive the copy of the judicial inquiry report. Stop. Registry is accordingly directed to furnish a copy of the judicial inquiry report to the learned counsel for the petitioner so as to enable the petitioner to file response by way of affidavit to the judicial inquiry report. listed after 3 weeks. Okay, wait. The judicial inquiry report shall be furnished to the learned counsel for the petitioner within a period of 3 days from today. Listed after 3 weeks.
Much obliged.
What is the matter?
Regarding my acquisition of land, now here what happened, the land has to be, they have filed this petition. Projecting in the PR, they are representing the affected land owner. But now when I come to know that this has been filed, the PR projecting himself the affected landowner, so we got included. We are respondent, we are the actual affected landowner. We don't have an objection for acquiring a land for the for Paran hydroelectric project. According to this, we got completed and we filed objection. Thereafter, they are not appearing. Now the land has been acquired and a compensation has been paid to all affected land. We have also received. We have done it. Now the petition is not valid.
So your submission is that this PIL has become more or less infructuous.
Madam. Because they actually the bona fide of the petitioner was also doubtful. And earlier occasion, there's also observation.
Which observation?
Uh,
Which order?
Madam.
This
18/8/2022.
18?
18 August 2022 was filed.
22.
Yes.
This the matter was last listed on 1/5/2023.
Last occasion also petitioner counsel they did not have.
No, last
Because
reappeared. N. Nibu. Last time N. Nibu, learned counsel for the petition, appeared.
thereafter, madam, they have not had.
Thereafter, the case has not been fixed.
On 2/5/2023, petitioner counsel they remain absent.
2/5,
2/5.
2/5/20,
3. 2023.
no, 1/5/2023. 1/5/2023. This matter was listed before the Honorable Chief Justice and myself. And their order has been passed that the learned counsel for the petitioner has appeared. Thereafter, I don't see any order. I don't know. Thereafter,
27/6/2023, the council has withdrawn from the case. By order 27/June 2023. 23, man.
June, just
27/6/2023.
27/6
2023.
to 23. Oh, 27/6.
It's a 27/6.
9/8.
9/8 also.
Yes.
Wait,
9/8.
it's with 9/8.
On 27/6/2023, Mr. S. Mo, the learned counsel. Who is Mr. S. Mo? The learned counsel had submitted that he will be filing his wakalatnama.
Your Lordship, it's my senior,
Ah,
ESMO. I haven't checked.
so what happens now?
Your Lordship,
What happens?
Nothing, Your Lordship.
S. Mo,
Yes.
is he still interested to pursue the matter?
I'm not aware of it. I will inform this.
Okay, cancel that. MS so learned counsel, appearing on behalf of Mr. S. Mo, the leading counsel in the case, the leading counsel for the petitioner, submits that she may be allowed some time to seek necessary clarifications. Prayer is allowed, listed after 2 weeks.
Major-
On this matter.
Yes. Yes. Yes, Mr. M. Kato.
My lord.
You were mentioning this case.
Yes, my lord. My lord, I may be allowed to withdraw with liberty to file a fresh, my lord.
Okay.
Yes, that is my lord.
Mr. M. Kato. You are the counsel for the petitioner?
My lord.
The
App-
learned
appellant,
counsel for
madam.
the petitioner submits that he may be allowed to withdraw the writ appeal with liberty to file afresh. Prayer is allowed. Writ appeal allowed to be withdrawn with liberty to file afresh. Stop. In this IA, okay, in view of the order passed in WA 3/2024, the IA stands disposed. Okay.
My lord. Deeply obliged.
May I sign, my lord?
Yes, please.
I beg to mention, my lord, item number 18, my lord.
18.
Yes, my lord, 18, my lord. Supplementary hearing this, my lord, 18.
18. Yes, yes.
I am for, my lord, respondent number 10 to 14, my lord, with the
10.
consent
10 to 14.
46, my lord.
10 to 46.
My lord. With consent of other side, may I pray that this will state after 3 weeks, my lord.
Mr. So-and-so. The learned counsel for the respondent number 10 to 46. 6 adjournment of the case for 3 weeks. Stop. The consent of the other side has been obtained. Prayer is allowed, listed accordingly.
Obvious, my lord.
My lord, may I mention item number 10, my lord? Here, item number 10, my lord. Orders, my lord. Here I am for the private respondent, my lord. My lord, I need to file, my lord,
Item 10.
affidavit, my lord.
You're for private respondent?
Private respondent, my lord.
Private respondent.
Yes, my lord. And moreover, counsel of the, my lord, for the department is also changed, my lord.
My lord, I'm appearing for the education department and my name may also be reflected in the cause list. My name is not here. I'm
Okay.
looking, just I've been entrusted to look after this case.
So therefore, my lord, at this issue, my lord, 4 weeks time may be granted. In the meantime, my lord, we'll file affidavit, my lord.
Mr. M. Kato. The learned counsel for the respondent. For the private respondent.
Private respondent.
6 adjournment of the case for 3 weeks to file the affidavit in opposition. Prayer is allowed, listed accordingly. The name of Mr.
T. Tagu,
So-and-so,
education,
standing counsel,
education department.
education department shall be reflected in the daily cause list.
My lord,
Yes,
my lord, item number 3, my lord. My lord, this matter may be released after 3 weeks, my lord. My senior is out of
Out of station.
My lord, he's not feeling well, my lord. So because
Who
of
is your
the matter.
senior?
N. Dangan, my lord.
N.
Dangan.
N. Dangan.
Nikita Dangan, my lord. Nikita.
Mr. So-and-so, learned counsel, makes a mention on behalf of N. Dangan, the learned counsel for petitioner, and 6 for adjournment, and 6 the adjournment of the case for 3 weeks on the ground that the counsel for the petitioner is indisposed. Prayer is allowed, listed after 3 weeks.
My lord, I beg to mention item number 1, my lord. Admission, my lord. My lord, may I pray, my lord, this matter may be listed after 4 weeks, my lord. I've taken consent of the petitioner
You are
counsel.
the counsel for the
I'm for the education
SC.
department.
SC.
Yes, my lord, standing
Okay.
counsel, education department. And my
the
name is
ground?
not there, my lord.
Ground for adjournment
My lord,
to file affidavit.
my lord, not my lord, that relevant file record that has that I had to receive from the previous council when I'm appearing in this case, my lord, for the first time, my lord. I've been entrusted to
Okay.
look after, my lord. As a standing counsel, my lord. I'm taking
Mr.
over the matter, my lord.
Tagum Jamu.
Yes,
Tagum
and my
Jamu.
name is Taba Tagum. I'm taking over the
Okay,
case
okay.
from him, my lord.
Mr.
Taba Tagum, T
Taba
Tagum,
Tagum.
yes,
Okay.
my lord.
Mr. Taba Tagum submits, the learned standing counsel education submits that he has been recently entrusted to take over the file. And therefore 6 for 3 weeks time. Prayer
My
is
lord,
allowed.
4 weeks time, my lord.
Okay, no difference, 3 weeks, 4 weeks. Let's
My
start
lord,
that.
my lord, my lord.
Okay.
Please, your lordship, I would like to mention item number 5. This matter may be fixed on 13 February. Here, the senior counsel, PK Tiwari is going to appear on 13th. Item number 5.
You are the counsel for the,
Petitioner.
what is 13? What is so auspicious on 13?
Your lordship, he is coming on 12 and 13 from Guwahati. So, yeah.
Mr. So-and-so. Learned counsel for the petitioner.
Petitioner, Your Lordship.
Sixth adjournment of the case on 13/2/2023-24,
Matter may be fixed on 13, Your Lordship,
listed accordingly.
on 13 February.
Yes. Okay,
Of
next.
Lordship, I beg to mention item number 15 and 16 on behalf of A Tatak.
15 and
16, Your Honor. The matter may be fixed on 12, Your Honor. I have taken the consent from the other side. I'm for the respondent.
any other day besides 12.
Then, Your Honor, on 15,
15 is a holiday.
If I may, Your Lordship, my lord, we are appealing for the petitioner, Your Lordship. There is an urgency in this matter since this is a tender matter, Your Lordship, and there is no interim order, Your Lord. And the work is on progress, is going on, Your Lordship. That is why.
If it is going on, then it's against you.
But still, Your Lordship, if this court interferes in the later stage, that is why there is an urgency.
This is item
15 and 16, Your Honor.
listed after 2 weeks. Okay.
My lord, in the, there's an urgency, Your Lordship. You may kindly
Okay.
consider that.
That's all right, since the work is in progress.
No, Your Lord, but still, my lord, there is no interim order. That is why we are present for a
There's no
particular
interim
day.
order, that's why I'm listing it after 2 weeks.
My lord, in that case, a
Okay, next.
fixed date may be given, Your Lordship obliges.
To 2 weeks, okay.
On 16th, Your Lordship, in that
Okay,
case.
next.
May I, Your Lordship?
Ah,
I beg to mention item number 17.
17.
Yes. We are for the petitioner side.
Yes.
Since conducting counsel is out of session, so kindly adjourn the matter. 3 weeks may be given.
Mr. So-and-so, learned counsel submits that. Who is the leading counsel?
Our sonar.
Mr. R. Sonar. The leading counsel for the petitioner is out of station and therefore seeks adjournment of the case after 3 weeks. Prayer is allowed, listed accordingly. Okay.
Much obliged.
May Your Lordship,
Yes, please.
I would like to mention item number 11. Lordship, we have taken the consent from other party. So this matter may be listed after 3 weeks.
You are mentioning on behalf of
Petitioner,
petitioner.
yes,
Mr. So, item 11,
yes.
Mr. So-and-so. Learned counsel for the petitioner seeks adjournment of the case after 3 weeks. Prayer is allowed, listed accordingly. Okay.
May I, Your Lordship?
Yes, please. Yes.
I beg to mention item number 2.
Item 2.
Yes, and I'm for respondent number two.
Item 2, 2. Yes.
My senior counsel is out of session, so this matter may be listed after 4 weeks.
Mr. So-and-so. Learned counsel makes a mention on behalf of
G. Talo.
G. Talo,
Yes.
the learned counsel for the respondent number 2, and seeks adjournment of the case after 3 weeks. Prayer is allowed, listed accordingly. Okay.
Deeply obliged.
May I please, my lord?
Yes, please.
My lord, I beg to mention item number 13 and 14, my lord.
13 and 14.
Yes, my lord, on behalf of Huay Doloy, my lord.
On behalf of
Huay Doloy, my lord.
Y. Doloy.
Yes, my lord.
Mr. So-and-so. Learned counsel makes a mention on behalf of Y. Doloy, the learned counsel for the petitioner, and seeks adjournment of the case for
My lord, can it be on 22, my lord? He is coming on 22, my lord.
2 weeks. Prayer is allowed, list recorded. Okay.
Obliged.
Yeah, please, Your Lordship.
Yes, please.
Lordship, I beg to mention item number 7 to 9, Lordship.
7 to
9, Lordship. In item number 7, Lordship, I'm for the private respondent, Lordship. And item number 8 and 9, I'm for the petitioner, Lordship. These are the connected matters, Lordship. Lordship, what happened, Lordship, earlier in this matter, Lordship, the senior counsel, Mr. I. Chaudhary, was appearing in this matter, Lordship. But after he was being appointed as a AG, Lordship. So the client, they are looking for another senior to engage in this matter, Lordship. So in that view, the matter, Lordship, I humbly pray that this matter may be taken up after 4 weeks, Lordship.
your good name?
T. Garam, Lordship.
T. Garam.
Garam, Lordship.
Mr. T. Garam. The learned counsel for the respondent, private respondent in WPC 459/2019. 6 for 3 weeks' time to engage a senior counsel to represent the respondent in the case. Prayer is allowed, listed of the 3 weeks. Okay.
Lordship, in item number 8, there is an interim. Let me be continued.
The interim order passed in WPC 3/2022 shall continue till the next returnable date.
Deeply obliged.
My lord,
This matter is listed on 17th.
my lord, there's one.
Yesterday I was not aware, you had not brought this to my knowledge.
My lord, there is one, my lord, communication gap. That's why, my lord, this has been mentioned, my lord. The earlier this was sought for the obtaining instruction, my lord, saying that the work will not be finalized. Now we come to know that this work order has been awarded before the passing the order, my lord. That's why, my lord, it was required to brought before this honorable court, bring before this fact before this honorable. There's a change of situation, my lord, because this was passed, the order was passed on the submission that.
Yes, Mr. Counsel, where is your assurance?
My assurance, if till return on the last listing date, there was no instruction. So I said till then work will not finalize. But before passing of this interim order, work is not yet started, but it's already aborted.
It's communication gap, it seems, my lord.
Because of this interim order, work is yet to be started now, execution of the work. But work order has been already issued before passing of the interim order.
So in this situation, my respectful submission, let notice be issued, my lord, in that, because it was for issuance of notice only, this instruction on short court. Now at that point of time, the situation was different. Now it's come to know that work order has been issued, my lord. That's why at least, although they are public interest, my lord, the projects there. So that's why at least to examine the legality, my lord, the notice may be issued. Let them come up with the affidavit, my lord, because here notice has not been issued, my lord, because of assurance.
Mr. Sanso, learned counsel for the petitioner. Stop, as prayed for by the learned counsel for the petitioner. Issue notice to the respondents, returnable within 4 weeks. You represent?
RWD, Rural Work Department.
Respondent, which?
Respondent.
You are the standing counsel?
Yes.
Standing counsel for?
RWD, Rural.
RWD. 1, 2,
6, 7 also.
7. Mr. Sanso. The learned standing counsel RWD represents respondent number 1 to 6. 1 to 7. 1 to 7. 1 to 7.
Yes.
Therefore, no formal notice need be issued to the said respondents. The learned counsel for the petitioner shall however serve requisite copies of the writ petition to the learned standing counsel within a period of 3 days from today. insofar as respondent number 8 and 9 are concerned, the learned counsel for the petitioner shall take steps for service of notice upon the said respondents by registered post with AD within a period of 3 days from today.
My lord.
Listed
My
above.
lord, the instruction of the department may be brought in record, my lord, that they have issued a work order, my lord. Otherwise, that the earlier issuance that will my lord, contradiction, my lord. That's why, my lord. It was earlier in 2029, my lord. It was said that it will not be finalized. But now the fact has come before this honorable court that work order has been issued, my lord. That may be reflected, my lord.
On the next date fixed, the learned standing counsel shall place the record before the school.
Duly applied, my lord.
Lordship, may I please, your Lordship? Lordship, may I pray that Lordship, the Lordship may taken up the item number 24 first, Lordship. Item number 24, Lordship. Because Lordship, the imping order, Lordship, it has been issued a common imping order, Lordship. So I'll start with the item number 24, Lordship.
Why you have not annexed the impugn order in 22?
No, Lordship, 22 and 23, I have annexed, Lordship. But there is a certain complication. I'll come to that
No,
point later,
come to
Lordship.
22. Let us go serially.
All right, Lordship.
Yes.
Lordship. May I please, Lordship? Lordship, on NIT was issued by the respondent number 3, Lordship, for the supply and procurement under MG Narega, Lordship, in 2023 and 2024, Lordship. After the NIT, Lordship, on 5/10/2023, Lordship, the bid of the all the bidders were opened by the bidders of the bid were opened by the Technical Evaluation Board, Lordship. But in the meantime, Lordship, the respondent number 3, Lordship, respondent authority has refused to open my bid, Lordship. Instead of complying with all the fulfillment of all the condition of the NIT, which has been prescribed in the SBD as well, Lordship. Now thereafter, Lordship, after their refusal, Lordship, I have approached this honorable court, Lordship, being WPC 485, Lordship, on the action of the for the action of the respondent authority. And this honorable court, Lordship, on the 9/10/2024, Lordship, has given a direction to the respondent authority to open the petitioner bid, Lordship. That is my bid, Lordship. Now, once the bid was opened, Lordship, I was declared to be L1, Lordship. And accordingly, the respondent number 2 has issued a LOI, Lordship, in favor of me.
Respondent number 2.
Lordship.
Who is the respondent number 2?
Respondent number 2, Lordship, that is the director, Lordship.
Director.
Lordship.
Okay.
And after that, Lordship, after the LOI was being issued, Lordship, and subsequently, agreement was executed between me and respondent number 3, Lordship. That is the signatory authority, Lordship. Now, after that, Lordship, work order has been also issued, Lordship. But in the meantime, Lordship, after the work order was issued, Lordship, I was mobilized my man and materials, Lordship, to fulfill the terms of the tender, Lordship. But in the meantime, Lordship, on 2/2/2024, Lordship, the respondent number 3, Lordship, respondent number 3 has issued an order, Lordship, by stating that your agreement has been withdrawn, Lordship, unilaterally, Lordship.
Who is respondent number 3?
Respondent number 3 is the Lordship, that is the officer, Lordship, who is executed agreement with me for the contract, Lordship.
Whether the respondent number 3 has the authority to withdraw the LOI issued by respondent number 2?
No, Lordship. That is why, Lordship. That is why I approached this honorable court, Lordship. Now, Lordship will see Annexer I, Lordship, page number 38, Lordship. That is the imping order, Lordship.
Page number?
Page number 38, Lordship.
38.
Lordship. Lordship. Withdrawal of MOU supply for this is, Lordship, to CR Enterprise, that is me, Lordship. The first one, Lordship.
CR Enterprise.
Lordship. I'm the power of attorney holder, Lordship.
This is issued by respondent number
3, Lordship.
project director.
Project director, Lordship.
And let us see your LOI.
Lordship.
Which page is that?
Lordship will find. Start from Lordship, Annexure E, Lordship, page number 30, Lordship.
Page 30. Page 30.
Sorry, Lordship, that is page 34, Lordship. Annexure F, Lordship. I'm sorry, Lordship.
Page 34.
Lordship, 34, Lordship. Lordship. To share, Lordship, letter of intent for procurement of material under Amji-Narega 2023-24 in respect of CD block chlorine, Lordship, Kurungumi district. Lordship will find at the down below, Lordship, that is the rural development, Lordship, director, Lordship, that is respondent number 2, Lordship.
Yes, whether this is permissible.
My lord, your lordship has stated.
Your officer.
My lord, your lordship on 5th of this February, my lord, has stated the LOI, my lord. In the same tender, my lord, this coloring.
But for a different work,
No, same. Same.
different package.
Same package, my lord.
Same package, Lordship.
Same package.
Oh.
The letter of intent has been issued by your lordship. This Monday, my lord.
Now, Lordship,
The letter of intent has been issued by me.
No, state, my lord. State by your lordship, my lord. On 5th of this, January, my lord, or February, my lord. This Monday, my lord. Interim order is with
Lordship,
him, my lord.
the Lordship, this matter has been filed yesterday, Lordship. And this order which has been passed by your Lordship, that is on 5th to 2024, Lordship. That order I have obtained, Lordship. But there, now, Lordship.
Just wait for the light. Don't be in a hurry.
Now, Lordship.
The problem is that, my lord, like before stay was granted.
Wait.
Oh,
Let us wait for the light.
just my lord, communicate.
Let us wait for the light. I can hear you, but I can't see you.
Yes, my lord. Just a discussion.
Yeah, why was the letter of intent state? On what ground?
On the ground that the board, my lord, in the district level, my lord, has prepared one, my lord, comparative statement, my lord, where he was not conferred as L1, my lord. It is a claim of the, my lord,
In the case.
in the writ petition, yes, sir. But, my lord, in fact, my lord, in that writ petition, there was no, my lord, comparative statement, my lord. They simply made a board proceeding, my lord. The comparative statement was conducted by, my lord, the headquarter, my lord.
they simply conducted a board proceeding and conferred L1, L2, L3. No comparative statement was made. Now, by conducting that board proceeding, they have forwarded it to the headquarters. Now, headquarters, my lord, made the comparative statement, my lord. In the comparative statement, my lord, that petitioner, my lord, whose technical bit was rejected, my lord, that I have submitted before your lordship. The technical bit of the, my lord, petitioner was rejected, my lord. So, my lord, but your lordship, my lord, has stated, my lord, the LOI.
May I
So-
please, your lordship?
So what happens to today's case?
Lordship, may I please, Lord?
I
So far as the
suggest-
Lordship, the submission advanced by my learned friend, Lordship. Now, Lordship, I have brought all the records, Lordship, by annexing the documents, Lordship, in my petition, Lordship. Now, Lordship, so far as your Lordship,
No, learned counsel,
Lordship,
if the LOI in those cases are steep,
Lordship,
and if it pertains to the same case,
Lordship,
will there be not some clash?
Lordship, Lordship, that's why, Lordship, to my humble understanding, Lordship. Hello, the counsel for the petitioner, Lordship, in that matter, Lordship, they have challenged the LOI, Lordship, which has been issued on 8/1/2024, Lordship. Now I'm before your Lordship, challenging the order passed by the respondent number 3, Lordship, which has been issued on 2/2/2024, Lordship. Now subsequently, Lordship, in this period, Lordship, after the LOI, Lordship, agreement was executed between me and the respondent, Lordship. And thereafter, Lordship, supply order has been also issued, Lordship.
That is why I just want to clarify my doubt.
Lordship.
Whether it is in regard to the same work.
Yes, my lord. There
Lordship,
would be
in the
conflict,
same,
my lord.
in the same mode.
I suggest he file appropriate application for vacation of interim, my lord. Because the interim has
If
been,
it is for same work, then
Lordship, for Lordship, clarity, Lordship.
because you see, just one thing.
Lordship.
If that impugn letter is stayed,
yes,
correct?
Lordship.
That means you will continue with your work.
Lordship. That's
So
why,
the
Lordship.
very purpose of filing this writ petition
No, Lordship.
serves no purpose for the government.
Lordship. Lordship, since I didn't receive the copy of the writ petition, Lordship, but the order which your Lordship has passed, Lordship, I have downloaded it from the internet, Lordship. And this order, Lordship,
Let
after
us see that order.
Let's-
be
let's-
very clear about that order.
it was certainly passed after finalization of, my lord, tender works.
So is it a case where actually the same work is allotted to two firms?
No, one
No,
firm,
Lordship.
one firm.
Lord.
The petitioner.
So why the same work? That's
For the
what-
same work, yes, my lord. The petitioner therein is the private respondent, my lord. He is the private respondent in that.
Oh, acha.
I have been impleaded as a private respondent, Lordship. May I, Lordship, just
Then
take
why did you file this case?
Lordship, this case has
You
been,
know,
no, Lordship, this case has been filed yesterday and this order has been
that is
uploaded
why
yesterday itself.
you know that actually in the previous case, you are the private respondent.
No, Lordship, I was not aware of that, Lordship. Lordship may just grant me 1 minute, Lordship, so that I'll clear the doubt of the Lordship. Now, Lordship, in this writ petition, Lordship, after perusing of the order which has been passed by your Lordship, this order, Lordship, they have basically challenged the LOI, Lordship. Now, subsequently, after the LOI, the agreement has been executed, Lordship. Supply order has been passed, Lordship. It's not the case that the petitioner is challenging after the LOI entire subsequent order, Lordship. There is a subsequent development has been already taken place, Lordship. Now, Lordship, this petition, Lordship, has been filed on 5/5/2024, Lordship. Now I'm before your Lordship on order which has been issued by the respondent number 3 on 2/2/2024, Lordship. So either way, Lordship, this interim order, it won't be affect me, Lordship.
Here you are the respondent number 8.
Lordship, after perishing of the order, yes, Lordship.
this case.
Yes, Lordship. Now, your Lordship,
Just wait,
now your Lordship,
just wait.
Lordship.
The LOI has been stayed.
Yes, my lord.
And there is also a further direction.
No, my lord.
The respondent authorities shall not finalize the tender till the next written.
Yes, my lord. But before that, before passing of that interim order, my lord, the tender was already finalized, my lord.
Oh.
That's why, Lordship. That's what I'm trying to point out, Lordship. The interim order passed by your Lordship will not affect me, Lordship. Because the subsequent development, because the person who approached your Lordship, they have already.
So the order passed by this court is infructuous.
Lordship.
No, they have to vacate it.
Now your Lordship will come.
Come for vacation.
Yes, come for vacation.
Come for vacation.
Yes.
Lordship, I'll come, Lordship. But in the meantime, Lord, the order which has been passed by the respondent authority on two, Lordship, that has to be stay, Lordship. Otherwise, Lordship, the entire financial.
If that is stayed, you will continue with the work. The whole purpose of filing this petition, insofar as the state is concerned.
Now, Lordship, that to my humble understanding, Lordship, this entire matter can be disposed within 1 week also. Till next week, Lordship, I'll file the IA as well as the affidavit of opposition. Your Lordship may kindly come to the page number 31 for a minute, Lordship.
We are not giving you any stay on this today. Maybe.
This matter may be clubbed with the
Yes.
other writ petitions, my
It will
lord.
be tagged together
Yes.
with the other writ petitions.
Yes.
Then we can hear everything.
Yes,
And you move IA for vacation of this.
yes, lord.
Lordship.
If not, everything will get jumbled up.
Yes, lord.
I understand, Lordship.
Ah.
All right, Lordship, then I'll do that,
Ah,
Lordship.
We'll
I'll
take
do
all
that.
this with WPC 49/2024.
All right, Lordship, then I'll try to file the IA within this week only.
That is up to you.
Lordship,
I have no say on that.
Lordship. Now, Lordship, item number 22, Lordship, 23, Lordship. That is also the same.
That be WPC
14,
50.
which one, my lord? The pending writ petitions, my lord.
No, which is similar to this.
Similar one, Lordship, the WPC 57, Lordship.
57, 58 also.
No, Lordship. 57, there is no litigation before this honorable court, Lordship.
57.
Or no, Lordship, 58, Lordship. That is in the other package, Lordship.
56, 57, my lord, it is pending before this honorable court.
Lordship.
The
What
issue.
about 58?
58, my lord, there is no case pending, my lord.
Okay.
So my humble prayer, Lordship, this matter may be take up with the other matter which is pending before this honorable court, Lordship. In the meantime, Lordship, in 58, Lordship, item number 58, that is item number.
Mr. So-and-so, learned counsel for the petitioner. List WPC 56, AP of 2024 and 57 AP of 2024, along with WPC 49/2024. Okay.
Lordship.
Yes.
No. I think no. 24.
24. Item 24. yes.
24.
24 is there.
Lordship.
What is this?
Lordship, this is the fact of the case is, Lordship, almost same, Lordship. Only is that, Lordship, the order which has been. Kindly come to the Lordship, the Annexure G, Lordship, page number 27, Lordship.
This is for a separate package.
Lordship, yes, this is for the separate package.
Annexure.
Annexure G, Lordship, page number 27, Lordship.
Yes.
Yes, Lordship, to JG Enterprise, that is the petitioner, Lordship.
Number 2.
Lordship,
Number 2.
Lordship,
This number 2 is the petitioner herein.
Lordship. Now, since Lordship, this in this matter, Lordship, there is no litigation pending before this honorable court, Lordship. Now the fact and everything is same, Lordship. LOI issued.
Oh.
I'm sorry, Lordship. May I continue, Lordship?
Now just tell me,
Lordship.
just tell me. Suppose if this court stays this order, stays this letter
Lordship.
to 2024, what
Lordship.
happens?
Then, Lordship, this
You will start with the work.
Yes, Lordship, because that mobilization has been already started, Lordship. And now, Lordship, this order is.
Yes, Mr. Government Advocate.
Yes.
What happens?
My lord, even I am bit puzzled, my lord, because my lord, this is my lord, very peculiar case, my lord. The senior officers, my lord, direct to issue the work order, my lord. Now he, my lord, the project director, this project director, my lord, the subordinate officer, also issues the supply order, and then again revoke it, my lord. I cannot say, well, it is actually an act of insubordination, my lord.
No, if suppose this letter dated 2/2/2024 is state,
My lord.
he works,
Yes, my lord.
Yes, Lord.
then his prayer in the petition is answered, finish.
Yes, my lord. That would be the final order, my lord.
More or less final order.
Yes, my lord. Whether
We
this
cannot
court
do
can
that.
give the final order in the interim, my lord.
That is what is confusing me.
Yes, sir.
So, Lordship, my humble understanding, Lordship, so far as the JG Enterprise is concerned, Lordship, and this matter, Lordship, because this order dated 2 February 2024, Lordship, it has been commonly mentioned CR Enterprise, and JG Enterprise, Lordship. Now, this 2 CR Enterprise, Lordship, is the litigation is already pending before this Honorable Court, Lordship. Now, since in the earlier one, Lordship has already clubbed that. So far as the JG Enterprise is concerned, Lordship, at least the status quo order may be maintained, Lordship, so that as of today, Lordship.
No, status quo order means you work.
No, Lordship, at least till the disposal of this matter, Lordship.
Till the disposal of this case, what?
I'll maintain the status because the man and mobilization has been already started. Will be stand here only, Lordship, till the finalization of the order come from this Honorable Court, Lordship. Now, Lordship, the 3 points I'm basically raised in this writ petition, Lordship. First,
No, I have understood your case.
Lordship.
I'm just concerned. If suppose this 2/2/2024 is state,
Lordship,
what consequence follows?
I beg your pardon, Lordship.
What consequence follows? You will work.
If
Then you're actually the answer in the writ petition has been answered.
no, Lordship,
Issue raised in the writ petition, yes.
if your
Nothing more to decide.
if your Lordship will issue a status quo order, Lordship, then the Lordship, we will, your Lordship may observe in the order, Lordship, till the finalization of this, the petitioner should not continue with the work order they did so and so, Lordship. That can be observed, Lordship.
We will not stay this. We will not stay this, but we will direct the state government not to award the work to any third party.
Lordship, that can.
My lord, if I may pray, my lord, if this matter can be listed on, my lord, Tuesday, my lord, because I will take some instruction or at 2, no, my lord, on Tuesday, my lord. Tuesday or Wednesday, my lord. Wednesday would be much better, my lord.
Why that auspicious day for you, Wednesday?
Because I will also be out of
Anything
session, my lord.
special?
No, my lord. In that case, my lord, in that event, we can dispose of the entire matter, my lord. Because there is a, my lord, conflict of, my lord, of own communication, my lord. The headquarters says something else and the district says something else, my lord.
The Lordship may
Listed again on, what is?
On, my lord.
Heard Mr. So-and-so, learned counsel for the petitioner. And Mr. So-and-so,
Yes, my lord.
learned government advocate for the state respondents.
Standing council, my lord.
Learned standing counsel, which department?
RD.
RD department.
Yes.
Listed again on
14.
14 to
Enable instruction, my lord.
2024. For enabling the standing council to place the necessary instructions before this court. Stop. Till then, the letter dated 2/2/2024 shall not be given effect to.
Lordship.
Okay. You come with instructions?
My lord.
Okay.
Obliged.
Deeply obliged, Lordship.
25.
May Lordship.
Yes.
Lordship, the factual matrix of the case is that, Lordship, on 23/3/2023, Lordship, an anonymous email was received from some unknown person, Lordship, stating that there has been illegal appointment in Rajiv Gandhi University in the post of associate professor, Lordship. So to that effect, Lordship, upon receiving that email, Lordship,
I came to learn that the facts and the proof which has been given in that email is correct, Lordship. To that effect, Lordship, I have write a representation to the respondent authorities, Lordship. But respondent authorities, in spite of taking action into that, Lordship, they are issuing so cause notice to me, Lordship. Lordship, that so cause notice in annexure 4, Lordship. May I, Lordship? Annexure 4, page number 29, Lordship.
Page
29, Lordship. Page 29. May I, Lordship? Whereas it has been observed that the letter addressed to the registrar RGU submitted by Dr. Kurmendra, Department of ECE RGU with a copy of the Vice Chancellor, both hard and email copy attached, has not been routed through proper channel. As such, the normal procedure was not maintained and followed by him. Whereas it has been noted that any communication addressed to the higher competent authority must come through proper channel. If a letter is written by a faculty member, it must come through HOD and Dean of concerned department faculty. If it is going out of campus, then it must go through the registrar. The above act on the part of Dr. Kurmendra amounts to breach of professional ethics, procedure of university and CCS conduct rules. Hence, a so cause notice is issued against Dr. Kurmendra as to why disciplinary action should not be initiated against him. The reply must reach to the undersigned letters by 20th April 2023. Lordship, to this so cause notice, Lordship, I have replied on annexure 5, Lordship. Page number 30, Lordship. To this so cause notice, Lordship. Lordship, para 1, Lordship. I and other stakeholders of the university have received an email about the serious concern related to recruitment issue in the university. And as a concerned and upright employee of the university, I have forwarded my observation to the Vice Chancellor and Registrar for appropriate action. Since the matter pertains to my department, it further becomes my professional and ethical obligation to inform the competent authorities about my observation in the best interest of the institution. Lordship, I have just informed that there has been some irregularities done in the appointment process, Lordship. And also in para 4 also, Lordship. Further, the remark of not being forwarded through HOD is inappropriate and mistaken again, as I myself was the head in charge of the department on the day I submitted my representation. Further, forwarding to the office of the dean breaches confidentiality, as the dean itself remains a party to the process regarding which I have submitted my grievances representation, Lordship. This regarding, Lordship, the respondent authorities so cause notice stating that letter has not been routed through proper channel, Lordship. As Lordship, I was the HOD in HOD when I was submitting the representation, Lordship. Again, Lordship, subsequently, Lordship, one so cause notice was issued on dated 20th April, issued on 13th June, Lordship. That is on page in annexure 6, Lordship, page 32. To Dr. Kurmendra, Assistant Professor, Department of ECE, Rajiv Gandhi University, Ronohill, Temugu. With reference to your letter number cited above on the so cause notice issued to you by order so and so dated 18 April, this is to inform you that the reply clarification are beyond reasonable and far from satisfactory. Further, you are to clarify how you could get access to the confidential information relating to the screening committee report about Dr. Sanju Mehta. Your claims of having evidences as enumerated in your letter must be declared in affidavit on judicial paper along with facts and evidence. On mere assumption, speculation, the grievances cannot be entertained. Hence, your reply with the documentary evidence and declaration affidavit must be submitted within a period of 1 week for the further necessary consideration. Lordship, this is the subsequent so cause notice. To this also, Lordship, I have replied, Lordship, in annexure 7, Lordship, page 33, Lordship.
This is dated.
Lordship,
This show cause is dated. There are 3 dates.
yes, Lordship, dated actually dated 20th April, but issued on 13th June, Lordship, 2023. Lordship, replied to this so cause notice in annexure 7, Lordship. Again, Lordship, I have written a letter to the this so cause notice, Lordship. I have replied this so cause notice, Lordship. In para 1, Lordship, I have nowhere mentioned, Lordship.
Where is your show cause?
Yes, Lordship, I have again issued so cause notice, Lordship. Because, Lordship, in that so cause notice also they are stating that what I have replied earlier, what I have replied in earlier so cause notice is not satisfactory, Lordship. And in fact, they are alleging me that I have accessed the confidential screening information relating to screening committee report about Dr. Sanju Mehta, who is the who was appointed in associate professor, Lordship. And Lordship, my reply to this so cause notice is that, Lordship, I have nowhere in any of my communication on the matters have referred to the access regarding screening committee report, Lordship, citing which in my repeated memo, so cause notice is grossly presumptive on the part of the authority and reflective of prejudice mindset. I am attaching my all previous communication once again for your further reference. Lordship, this is the reply which I have replied to this so cause notice, Lordship. And Lordship, below this there are some facts, Lordship, Scoopers journal are there, but I am not going into that, Lordship. Again, Lordship, what happened, Lordship, the responding authorities, Lordship, again, they are issuing me so cause notice as a final reminder, Lordship. Same, Lordship, reiterating the same so cause notice, Lordship, in Annexure 8, Lordship, page 36, Lordship.
Which
Same-
is, which should be the date? This is 19 September.
Yes,
29,
19 September, issued on 27 September, Lordship. Lordship, same so cause notice as a final reminder, Lordship, reiterating this, same this one, so cause notice. Lordship. To this also, Lordship, I have submitted my reply in affidavit with notarization also, Lordship. And Lordship, in between this, Lordship, I have applied for so many NOCs also, Lordship, to apply for various universities in the departments. But Lordship, the responding authorities are not, Lordship, they are not bothered about me, Lordship, to issuing so cause notice. In fact, Lordship, they are just saying that what I have replied to their so cause notice is not satisfactory, Lordship. And Lordship, lastly, Lordship, in Annexure 11, Lordship, dated 13/10/2023, Lordship, this was the page 44, Lordship. This is the last request for NOC, Lordship, to the responding authorities from my side, Lordship, so that I can apply in Netaji Subhash University of Technology, New Delhi, Lordship. This is the NOC which I have requested from the concerned authority, but they have, again, they have said by denying that in Annexure 12, Lordship, page 45, Lordship. Page 45, Lordship, they are denying by saying that several complaints have been initiated by you through portals and the Court of Chief Commissioner for Persons with Disabilities, Lordship, Para 2 law, in Department of Empowerment of PWD, Ministry of Social Justice and Empowerment, New Delhi. The matter is under consider, Lordship. Of course, Lordship, I have initiated, Lordship, so many, I have initiated cases against this VC, Lordship, because Lordship, VC was just, Lordship, was illegally, the VC was harassing me, Lordship. And Lordship, even I have written a letter to the Chief Commissioner also, that urgent hearing of the cases, Lordship, which I have filed in Court of Chief Commissioner. But till today, Lordship, Court of Chief Commissioner have not bothered to issue any notice to the respondent authorities, Lordship. And the matter is still pending in Court of Chief Commissioner, Lordship. So I have come before you, Lordship, to at least, Lordship, set aside this all so cause notice, Lordship, which has been issued by the respondent authorities through illegally and biasness, Lordship. That's all, Lordship.
Yes, please.
My lord, the same matter is pending before the Honorable Court of Chief Commissioner for Persons and Disabilities. The same matter has been pending. We have filed the affidavit and this matter has not been disposed of till now. Same matter.
Lordship, as far as my concern, Lordship, that matter should be disposed within 3 months, Lordship, because I am a PWD person, Lordship.
My lord,
since June, Lordship, I have filed these cases, but Lordship, it's now 2024, Lordship. Still, this matter is pending, means what, Lordship?
All this matter has been raised before this court and till that the matter has not been disposed of.
Before this court?
Yes, my lord.
Before this
Before the court of, no, before that court, my lord. Before the court of Chief Commissioner. Annexure 13, my lord. Page 46.
This is a prayer from my side for Chief Commissioner, Lordship. Urgent hearing may be done, Lordship, but
what is the issue pending before the
Lordship,
Chief
same,
Commissioner?
Lordship, mental, physical, and financial harassment to the petitioner again by this respondent authorities, Lordship. By issuing NOC, Lordship, there are certain lots of things are there, Lordship, which I have not annexed, but today I have came only for NOC.
Have you mentioned that the same matter is pending before the chief commissioner?
Yes, Lordship, I have
Where
mentioned
have
it,
you
Lordship. I
mentioned
have just mentioned it. Lordship.
And before the commissioner, this chief commissioner, whether there is a prayer for quashing this show cause notice? Whether there is a prayer for quashing this show cause
That was
notice?
just, Lordship, a complaint, Lordship, against that.
My lord,
Vice
entire this matter has been raised before this court. This chief commissioner court.
Lordship,
And we
para
have
seven-
filed affidavit. I have prepared affidavit and we have filed affidavit on.
Lordship, in para 17, Lordship, I have mentioned it, Lordship.
No, what is your case before the chief commissioner?
Lordship, that was regarding mental harassment, mental, physical, and financial harassment by the responding authorities to the petitioner, Lordship.
That's why have you impugned the show cause notice before the chief commissioner?
Yes, Lordship, I have.
Have you impugned?
Yes, Lordship. But they have, the chief commissioner is not bothered to take about, Lordship. It's since June, Lordship, June 2023, Lordship, I have filed, but still this is 2024, Lordship. Not a single notice has been issued by the chief commissioner, Lordship.
My lord, notice has been
And in
issued
between this
and we
also-
have filed affidavit.
And in between this also, Lordship, I have applied for so many NOCs, Lordship. But the responding authority is not bothered to issue any NOCs to me, Lordship. So that, Lordship, I couldn't appear in different universities.
My lord, in this writ petition,
How can two parallel proceedings on the same issue be instituted?
the case number is 14260/1023/2023, my lord. This.
In fact, you should have filed a petition
Yes, Lordship.
for a direction to the chief commissioner to expedite the matter.
Lordship,
That prayer is not there.
Yes, Lordship, I haven't filed that one, but Lordship, I have just filed for the responding authorities only, Lordship.
No,
Commissioner, I
that-
have not filed.
you yourself you have submitted that you have actually impugned the show cause before the chief commissioner. You
Yes,
have impugned the show cause.
Yes, Lordship.
Then
But Lordship, there is no action.
you file a fresh petition on that. We'll see. We'll give a direction to the chief commissioner.
Yes, Lordship, direction may be issued to chief commissioner.
No, you have not read in this petition. You have not prayed in this petition. That should be a separate petition. You have not prayed in this petition. In your petition, you have only sought for quashing the impugned notices and for a direction to issue no objection certificate. That's all.
Yes,
So you file a fresh writ petition on that.
Yeah.
I think you have to withdraw this because we cannot allow two parallel proceedings.
Yes. Fine, Lordship, then I will.
You withdraw this.
Yes, Lordship, I will.
Okay, and you
With the
file a fresh
liberty-
petition.
Yes, with the liberty.
Okay, seeking for a direction.
Yes.
Okay. To let the chief commissioner expedite the proceedings before the forum. Okay.
Yes, Lordship.
Mr. So-and-so, the learned counsel for the petitioner submits that he may be allowed to withdraw the writ petition with liberty to file afresh. Prayer is allowed, petition is allowed to be withdrawn with liberty to file afresh. Okay.
Obliged.
Messenger.
You are out of service,
My lord.
out of service.
My lord.
We should notice.
My humble submission on the prima facie, my lord, this, my lord.
You are out of service.
Yes, my lord.
So let us examine the matter. Whether the termination issued against you is in accordance with law or not. We'll issue that.
Okay.
At this stage, we cannot direct your reinstatement. Right, Mr. So-and-so? learned counsel for the petitioner. The present writ petition has been filed, challenging the termination order dated 11/12/2023.
My lord.
Passed by the CEO, cum State Mission Director, Arunachal State Rural Livelihood Mission, Government of Arunachal Pradesh, Itanagar. Terminating the service of the petitioner from the post of Block Mission Manager, A small r, SRLM, all capital. Stop. Issue notice to the respondents, returnable in 4 weeks' time. Madam, you are representing?
Only for respondent number 1, Your Lordship.
Only for one.
Yes, Your Lordship.
Okay. MS so learned government advocate
Yes, Your Lordship.
appears for the respondent number 1. Stop. The learned counsel for the petitioner shall take steps for service of notice upon the respondent number 2, 3, 4, 5, 6, and 7 by registered post with AD within a period of
1 week, madam.
within a period of 7 days from today. Okay.
Obviously.
Yes, Your Lordship.
May I please, madam? Madam, this is contempt application, madam, for violation of honorable court's order, madam, dated 14/6/2022.
Who's for the other side?
Madam, yes, madam. It's a, madam, now, madam, the respondent number 1 and madam 3, they have been, madam, replaced by new, madam, incumbent commissioners, madam. Commissioner and that
Respondent,
1,
1,
2, and 3, my lord. So, my lord, I may be allowed to implement those new incumbent commissioners, my lord. and that
respondent number 1, 2, and 3.
2 and 3, my lord. They has been replaced, my lord, by new incumbents, my lord. So, I may be allowed to implement the new incumbents,
1, 2, and 3.
my lord.
Mr. Senso, learned counsel for the petitioner submits that he may be allowed to file an application impleting the new respondent number, impleting the incumbent respondent number 1, 2, and 3.
My lord.
Prayer is allowed. Listed after 3 weeks.
Well, I have further submission, my lord, for lordship consideration, my lord. This is a, my lord, land compensation matter, my lord. Well, in the, my lord, we may pendency of this contempt application, my lord. We may be, the landowners may be allowed to file a reference under the section 64 of the Fair Act, my lord. Regarding, my lord,
Let us first see, this is a contempt, let us see.
my lord, just an observation, my lord.
No observation in contempt, that will be for this court to. I think it will not be proper for this court. In the contempt, strictly contempt,
My lord,
whether actually the order passed by this court has been complied. with.
I'm
No.
submitting this, my lord, on the ground, my lord. I have filed and, my lord, reference application before.
That is a different issue. We
My lord,
cannot pass that order in contempt.
My lord, the learned court
Next.
verbally.
I may please, Your Lordship.
Yes, ma'am.
No, this case has been filed by the petitioner for retrieving two years of salary which has been withheld by the government. 2 years from February 2020 to March 2022. Yes.
Pending salary,
Yes, Your Honor.
salary,
Salary.
pay.
Your Lordship,
If the petitioner has worked, pay. You cannot extract his work and then leave him high and dry.
yes, Your Lordship, that is true, Your Lordship.
Your Honor, pleadings are complete in this case, so the matter may be fixed for final hearing and discussion.
Arey, madam, I'm asking him to pay. You are actually like coming in between.
Your Lordship, a direction may be given to the authorities to release his pending salary, Your Lordship, without going to the marriage.
Petitioner is not only claiming for the salary, but
Okay, we
along
will-
with
we
interest.
will- It is submitted by the learned counsel for the petitioner. That pleadings are completed and therefore the matter can be listed for hearing. Listed for hearing in the usual course. Okay. Okay.
Oblige, Your Lordship.
Number 27. Verse 27.
May I submit, madam?
Very confusing. Yes.
My lord,
Yes.
my lord, I want to withdraw this matter, my lord. My
You
lord,
want to withdraw?
yes, my lord. Since they have issued a sanction.
You're for the
order.
petitioner?
Yes, I'm from.
Your good
petitioner.
name?
Oh, Dugong.
Oh,
Dugong.
this is item 20. Oh, 27, I'm sorry. Oh, Dugon,
Yes, my lord.
Mr. O. Dugon, the learned counsel for the petitioner submits that he has instructions to withdraw the petition
My lord, with liberty, my lord.
with liberty to file a fresh. Petition is accordingly allowed to be withdrawn with liberty to file a fresh. Okay.
Oblige.
Oblige.
Well. What is? कहाँ से कहाँ आता है? Why first list is prepared in this manner? Jumping here, there. Huh? Advanced list. Listed with two lists. So supplementary is you filing there. You fill up your- Yes, 12.
Yes.
What is this? Arbitration?
Yes, Your Honor.
Hmm?
Appointment of arbitrator.
Appointment of arbitration.
Yes, Your Honor.
My lord, arbitrator, my lord.
Arbitrator.
Yes, my lord.
Who are the parties?
My lord, one contract work was awarded to this
Yes.
petitioner,
Mr. M. Kato.
my lord.
Who are the parties?
My lord, only BRO, my lord, Border Road Organization,
Border Road Organization.
my lord. Work was awarded to this petitioners, my lord, for execution of the my lord, the road construction, my lord.
Huh.
And he has not completed, my lord. In the meantime, that has been, my lord, terminated, and he is, my lord, claiming for my lord, the resistant cost, my lord. For that, my lord, dispute, my lord, the matter has to be referred to the arbitration, my lord, by appointing arbitrators, my lord. My lord, we have on our list of arbitrators from retired judge of our own high court, my lord. And amongst all the, my lord, the list of arbitrators, if my lord,
Get that list. Let us see.
that might be, my lord, placed before. List of arbitrators, my lord, we have, my lord,
What is actually the agreement? Let us see. For appointment of arbitrators.
yes, my lord.
What is that agreement? No arbitrators from Arunachal?
Well, basically, well, we don't have arbitrators from Arunachal Pradesh.
Where is that agreement?
Contract agreement, my lord.
Especially the clause for appointment of arbitrators? Study your file and come. We will list it after 3 days.
No, sir.
Okay.
Yes, ma'am.
We'll list it after 3 days. You study and come.
No, sir.
List it after a week.
My lord. And
Please come
documents,
to
my
the-
lord, I'm having is also not.
You want arbitrators and you have to show this code, which is the clause
Yes, yes.
in the agreement which provides for appointment of arbitrators.
Correct.
Okay. Okay. List it after a week.
Deeply appreciated.
October 28 and 29.
Again. Oh. Yes, ma'am.
Ma'am, my lord,
Yeah.
I filed this IA for the withdrawal of the petition, my lord.
Withdrawal of
The writ petition, my lord, 378 of 2017, my lord, with liberty.
Okay. You for the petitioner?
Yes, my lord.
And in this IA, you are the applicant.
Yes, my lord.
You're the
I-
applicant.
Yes, my lord.
And in the writ petition, you are the petitioner.
Yes, my lord.
The heard Mr. MS Senso, learned counsel for the applicant. And MS Senso,
For all the respondents.
learned government advocate
Yes.
for the state respondents. By filing the present application, a prayer has been made for withdrawal of WPC 378/2017 with liberty to file afresh. Stop. The IA stands allowed and disposed. Stop. In WPC, okay? In view of the order passed in IA 22/2024, WPC 378/2017 is allowed to be withdrawn with liberty to file afresh. Okay.
Item number 19.
May I please, Lordship?
What is the matter?
Well, this is pertaining to purportedly an eviction order.
What?
Eviction order. I mean, the district authorities, they have stopped my construction. But actually, the lane is allotted to me. It is near the airport. It is admitted fact, but it is not on the runway, or not on the.
Who will allot you land on the runway?
No, no. I mean, within
Nobody will allot you land. on the
within
runway.
the right of runway, my lord. I mean, from the outside also. Now, my lord, I have, since it is an allotted lane, I wanted to construct a house there. So I have approached the deputy commissioner. Deputy commissioner has permitted me. And before that, the deputy commissioner has said a criteria that whoever construct the house should not, first thing is should not be a high-rise building. And the building must restrict itself to 7.08 meter. So with these conditions, I have applied and permission was granted to me. And I have.
Who is the expert authority? Who is the expert authority? Whether actually the airport authority is also a party here?
They are not the party.
They should be made a party. It is the airport authority who can say what height should be constructed, what height should not be constructed.
Lordship, this deputy commissioner's order is in contravention of the existing government notification, Lordship. In the government notification, it is very clear that within 100 periphery, there should not, any building construction should not be allowed.
Who
And
is the
Lordship-
authority to revoke that DC's order?
Lordship,
Who is the authority?
Lordship, the Civil Aviation Department has written complaint. They have filed FIR also against the petitioner.
They have objection
encroacher.
only of the high-rise,
And
high-rise
then,
building.
Lordship, this permission is a simple permission. Even here in the permission, they have mentioned that further any construction within a periphery of 100,
Madam,
Lordship.
if that order is not proper, if the order passed by
Yes,
deputy
not
commissioner is
proper
not
at all,
proper,
Lordship.
just listen to me.
Yes.
Is it not proper for the competent authority like the commissioner to actually revoke that order?
Yes.
Lordship, that's why, Lordship, eviction notice has been given. That's why, Lordship, to the all the encroachers. And we have said so that this is in contravention of the deputy commissioner's order, is in contravention of the existing government notification. That
Who has
cannot be
given the
said.
eviction notice? Who
Lordship-
has given the eviction notice?
Lordship, if Lordship come to the permission, this is a simple improper permission, Lordship.
Okay, you said the eviction process is on.
Yes,
Who has given that eviction notice?
eviction notice has been given by the,
ESC come estate officer.
yes, Lordship. Estate officer is given power here to give notice, eviction notices to the encroachers, Lordship.
Will it not contradict? Because deputy commissioner giving the order, then ESC.
Lordship, this order was, Lordship, not by the deputy commissioner also. This is
Yes.
signed by the 4 deputy commissioner, but by the Lordship,
No, that is. deputy
ESC,
that
Lordship,
is deputy
ESC, but
commissioner.
by the ESC.
SD is deputy commissioner.
Yes,
SD is deputy commissioner. That means in the original report, it is the deputy commissioner who has signed it.
Lordship,
Well,
whatever is that
the-
this is improper.
Yes,
The
right, just
original, Lordship, government notification, central notification is there with regard to the this landing ground, Lordship. Accordingly, the state government has also notified it, Lordship. Actually, it is 900 up to 900 Lordship meter. But then for high rise is
What have you
300.
challenged in your writ petition? What have you challenged?
my lord, this impugn order at
Who-
page 20,
Who has issued that?
that ESC come estate officer. Is under deputy commissioner. My lord,
But they
my
give the power
submission
to-
is, my lord, whatever it is, my occupation or construction is not unauthorized. First thing is, this is an allotted land. This is admitted in the government affidavit also. Secondly, I have, the deputy commissioner has set a parameter. And within that parameter, I have applied permission. Permission was granted.
My lord, whatever it is under the knowledge and permission of the authorities. I have not,
you cannot make that submission, whatever it is, because actually it endangers the life of the passengers.
Yes. In public
my lord,
interest.
in that case, the entire that area, there are even one of the biggest stadium is just adjacent to just one wall. Beyond that, there is a big stadium. The entire building are there. My lord, Pasighat is such, the airport has been established within the township area only. And my lord, there are hundreds of buildings. I have annexed my photograph also. There are high-rise building also. They are targeting only me and another one person only. There are more than 100 buildings there. Within the periphery of 100 meters or 900 meters, even the market is there. The main market, Pasighat town, market is within 900 meters of radius of 900 meters. Actually, my lord, the airport should not have been established within the township area. Now they have not cancelled my land allotment order also. They have not cancelled my permission granted by the deputy commissioner. And they have not cancelled the parameter that's set by the deputy commissioner. May I just take your lordship to the annexers, my lord? Lordship may.
The deputy commissioner order passed by the deputy commissioner, order passed by the authorities may be in your favor. But this court will see whether actually your construction risk the life of the passengers. That is the main issue. If that is there, then we have to.
Yes. My lord, I have annexed the photo also. It is only one story only. It is not even 7 meters. Actually, the permissible height, which is 7 meters, it will come to the double story. But my lord, I have my building is not 7 meters. It is only the first floor, only about 10-12 feet only. It is not a high-rise building, my lord. Now, my lord, I mean, such a precarious situations now. Allotment is there. The land is under my occupations. The district authorities in general has set a parameter. Only they have debarred high-rise building. My building is not a high-rise building. I have taken special permission to go ahead with the constructions. I have constructed my house building structure. I have invested my money also.
Well, what is the status of your building? You have constructed the house?
Yes, my lord.
Already there?
It's already, my lord. My lord, at page 5, I have annexed that photograph, the rooftop. It is only one story only. Your lordship will find that there is no provisions for another story.
What is the permission granted to you for construction of how many storied or what height?
No, permission is for up to 7.08 meter. But no high-rise building.
Ground floor only that is, lordship. 7.8 meter means, lordship, if your lordship come to my affidavit, lordship.
No, my lord, let us first go to my annexers, annexer 1. Here it is fixed at 7.08
madam.
meters.
Yes.
Yes, lordship.
What happens to DC's order? Tell me.
Lordship may kindly see the order, lordship. My annexer 1, my affidavit, lordship.
What is that?
Lordship, see here, lordship. Mrs. Indra Talo, the petitioner, so-and-so, the King Village, Pasighat is hereby granted the permission to construct ground floor, lordship.
Okay, ground floor.
Building at Jakong area, so-and-so, lordship. And in second para, they have, it is stated the construction of the building should strictly limit to the permitted level of ground floor. And further, any construction within a periphery of 100 meter of ALG and in the line of right runway is prohibited, lordship. And in this lordship verification report, lordship may kindly in annexure 2, on verification, it was found that a construction of RCC building was in progress at an approx distance of around 15-20 meters, lordship, from boundary, lordship. It is within 15 to 20 meters, his construction is, lordship.
But it's
whereas, lordship, here it has been already mentioned that within, it has been stated in the permission order also. further any construction. Lordship is usually here, the officers, they sit in the office, and if someone comes and asks for permission, or in our area especially, all are relatives only, Lordship. So they, without seeing the area and without verifying the distance, Lordship, they just give permission. And here also they have given only ground floor, but then in reality, she have built one-story building, Lordship. And verification says that
verification
it is within 15 to 20 kilometers, Lordship.
not
That
find
is
any-
very dangerous, Lordship.
did not find any violation of the permission granted, my lord.
You take a chance in another court. Considering the safety of the passengers, I am not actually inclined to.
And Lordship, we have annexed so many complaint letter from the airport authority.
There also, my lord, they have,
Lordship.
their specific is the high-rise building.
No, Lordship.
Mine is not a high-rise building.
They have named her also, Lordship, in the airport authority, Lordship. Her name is also there. Even they have even filed FIR, Lordship. I have annexed all the Lordship documents here in my.
But actually, see, actually, the government is trying to shift its responsibilities to the court. If the deputy commissioner has issued the order, higher authorities are there. If the order is not in accordance with law, then the higher authorities can revoke that order.
Yes.
Or the deputy commissioner himself or herself can recall the order. Why are you shifting all this to the court? Which can be done by the authorities.
When they started the construction, the deputy commissioner who have given the permission, he was transferred.
No, madam.
Lordship, that I understand,
The
Lordship.
government is still alive.
Lordship, I
You are
understand.
actually making a submission as if there is no government.
Lordship,
That should not be.
Lordship, I understand that.
Listed after 3 weeks.
But can it be on 21?
Not before me. Listed after 3 weeks.
Lordship.
Obliged.
Yes. Yes, Mr. What is this about?
It's the termination, illegal termination.
Illegal termination?
Yes, Your
My lord, normally, the ITBP and the other defense force, my lord, they never, my lord, terminated the employees without, my lord, the following the due process of law, my lord. This is the same case where, my lord, everything has been followed. Even FIR was lodged, even, my lord, the letter of intimations for the, my lord, searching out of this, my lord, the petitioner. He was absent from the service for long period, my lord. Ultimately, my lord, the ITBP issued a termination order, my lord, after giving several opportunities.
Departmental inquiry conducted?
Yes, my lord.
Inquiry, before desertion, he haven't received any inquiry, this show cause notice. After desertion and after termination, he have received before termination, they have sent show cause notice, but the show cause notice he received after the termination letter he received. So there are some loopholes.
Yes, Mr. Kato, why show cause notice after termination?
My lord, first of all, FIR was lodged to search him out, my lord. And he was on unauthorized leave. After that, my lord, even findings no way out, my lord, termination order has been issued, my lord. From the record, it is very transparent, my lord, fair opportunity has been given, my lord. Even after terminations, him from service, my lord, after 1 year almost, my lord, he approached the ITBPs, my lord. And then now, my lord, the termination was done in the year 2014, my lord.
14?
14, my lord. And he approached the ITBPs after 15, my lord, 2015, in 2015, my lord. And now writ petition has been filed. Now, my lord, at this stage, he was appointed for the, my lord, the general duty, my lord, GD, as constable, my lord, GD constable. Now, my lord, now important point is, my lord, now at this stage, even if his case is considered for, my lord, the reinstatement in the service, my lord, GD duty is such a duty where, my lord, the physical, the fitness of the person is required, my lord. Now,
What is GD?
General duty.
General duty.
My lord.
Your Lordship, he's just in 32 years old. I guess it's young enough to work as an GD.
No,
He was recruited in he was at the age of 19. Now he's just 32. In 32 age, I guess it's young.
Then why come so late?
Your Lordship, actually, he approached to the authorities in 2014 itself, but they didn't consider it. And after that, he went to the West Bengal High Court, but it was due to lack of territorial jurisdiction. They haven't took the case. And after that, he approached to the High Court Itanagar, but here also he haven't get the relief because of territorial jurisdiction. And the court, the appellate authority was from here he have sent to the Central Administrative Tribunal, but Central Administrative Tribunal doesn't take the force these matters. So again, they dismissed, and again he come back to here in 2019. The court have sent him to the appellate authority. From appellate authority also he haven't get any relief. So after again he approached here in the High Court.
Well, you mean to say that the appellate authority dismisses case?
Yes, but there is no cogent reason have given for the dismissal of
Appellate authority which?
DIG Tezpur.
DIG?
Tezpur.
He is the appellate
ITBP.
authority.
Yes, yes, Your Lordship. If Your Lordship may permit, then I may like to go to the impugn orders.
Okay, let us see. All the parties are present, eh?
Yes, Your Lordship. May I, Your Lordship?
Yes, come. Let us see.
Your Lordship, I will start from the beginning. So it's on 25th October 2011, the petitioner was appointed as an GD constable in ITBP 4th Battalion. So on 12th of November 2011, he have joined there. During the course of training on 25th February 2012 at 3rd Battalion, he was going through the training and he got injured his right hand. And after that, he didn't cured from that injury. On 8th of February 2012, he was taken to Bareilly District Hospital because he went for training in Bareilly. So he was taken to Bareilly Hospital, but he didn't cured and he was going through the pain and the injury, but the authorities haven't cured him. So on 25 to 9th, he was in ITBP Hospital, Bareilly. From the Bareilly Hospital he have taken to ITBP Bareilly Hospital, but he didn't receive any proper care from there. That again on 10th of April, it's been long now, more than a month that he's in like injury, but they didn't give any proper treatment to him. So still he was in, his hand started swelling and his elbow joint are in pain, and he had taken to Unit Hospital, Battalion Dirang, the Dirang where he was posted. So he was taken there. And we know that in Dirang, it is in the rural area and there won't be any proper care. They have taken him back to the Dirang, then he didn't got any proper care there. And from there, the doctor couldn't give him the proper treatment, so they have referred him to the Guwahati CRPF for proper treatment. And after reaching Guwahati, he have granted 42 days leave. It means his injury was quite difficult and like he need rest. So he went for 42 days leave that was granted by CRPF doctor from there, and he left for his home. But after 42 days 42 days also he didn't cure properly, but his leave was already over, so he had to come back to the unit and he have joined there. And he joined there, and after that also he didn't cure. Then again he went to Guwahati Medical College on 19/7/2012. There till now he was not getting any care from the unit, and he was going through all the pains. And he have done X-ray, but in X-ray report it also came out that there was fracture on his hand, but they just treated him with the painkillers, and he was just wrapped his hand, but he was going through all those things. And on 21/9/2012, petitioner left for his home because his mother was like, he got some information from home that he had to come back because his mother is not well. And so when he reached home, his mother was not home, and he got to know from his father that his mother is mentally and physically not well, so she can't. Yes, Your Lordship.
I appreciate you, but is there some seniors leading you in this case?
No, sir, I'm doing it. Your Lordship.
Because you are actually praying for, you are now out of service. You are now out of service.
Yes, Your Lordship.
You're praying for reinstatement.
Yes, Your Lordship.
Okay.
So on 29th September 2012, he went home, but he got leave from the battalion for his mother's taking care. But when he reached home, his mother was not there, and they had to look after. They were searching her, but on 7/12, on this December 12, 2012, his mother was died. So he has sent some leave applications, but
Why the petitioner should be reinstated? What is the legal stand?
I can give some judgments, and I will read out under which sections he have been.
No, it should be in relation to the facts of your case.
Because, Your Lordship, he didn't receive the show cause notice, first of all. It is the natural justice of the person that he should have been received the show cause notice. So he haven't received, and the provisions are given in their own ITBP Act that if someone have been deserted or terminated from the service, he should have given at least one chance to listen to him, but they didn't give any chance to him. If Your Lordship may permit, then I can go to the impugn order and I can read out the provisions.
Yes, let us see.
Your Lordship, it's in page number 56. It's a deserter order. the senior counsel have been mentioning about the one thing, so I would like to read out the second para of the order. Here, para second, second line, the, may I read?
What is this?
This is the deserter order. The authorities have filed FIR, and after that they have sent one apprehension letter to the Superintendent of Police, District Coach Bihar. So here it reads, the Superintendent of Police, District Coach Bihar, West Bengal was requested to apprehend and hand over the above individual to the Commandant, 4th Battalion, ITBP.
Where are you reading?
It's in page number 56, Your Lordship. It's para second para. Second line, the Superintendent of Police. May I? The Superintendent of Police, District Coach Bihar, West Bengal was also requested to apprehend and hand over the above individual to Commandant 4th Battalion, ITBP, wide so-and-so number on so-and-so date with so-and-so to SHO Police Station, Boxerhat, District Coach Bihar. But the concerned police didn't succeed in handing over the said individual, and nor any reply has been received so far. So it shows that the authorities have deserted the person in presumption that he don't want to continue his service. They didn't any bother to inquire whether he want to continue or not. So they just, in presumption, they have deserted the person. For this, I would like to place one judgment letter. Therefore, a court of inquiry was constituted. Wide. This is para 3, line, it's 5th line. Therefore, Your Lordship, may I read? Therefore, a court of inquiry was constituted wide so-and-so number on dated September 12, 2013 to inquire into the reason of absence of individual under the provisions contained in section 74 clause 1 of ITBP Act 1992. But they might have constituted any inquiry, but till now petitioner haven't received any report of this court of inquiry. What is happening in this court of inquiry, petitioner haven't received, and even the respondent haven't gave anything for this in their this.
You were not traceable. You were not traceable. As per this, you were not traceable.
Not traceable, but I would like to place this one judgment regarding this, Your Lordship.
Judgment is afterwards. Judgment afterwards. Let me satisfy with the facts. If you are not traceable, how actually the report should be served to you?
But Your Lordship, it's in para 2 where they said that they have served this apprehension letter to Superintendent of Police. Then Superintendent of Police have been informed to them that whether he is there or not there. But in my fact, I have provided that they came to my house. The Superintendent, this District Police of the Coach Bihar, they came to my house and they have asked. And I was in bed. I was sick and I was in bed. So they gave me some documents and he has signed it. But the Boxerhat police have, what they have done, I don't know, but they haven't informed to the authorities about that thing. So there is loopholes. So they should have been confirmed whether I am dead, I am alive. They haven't done anything about that thing. And they deserted according to this. In presumption, they have deserted. It is the violation of natural justice. They should have been informed, and they haven't provided any.
Is it not your duty to inform the authority?
Yes,
You are a member of a discipline force.
Yes.
Is it not your duty to inform the authority?
Yes, Your Lord. While I was leaving from this ITBP camp, I have requested for the leave, but they haven't provided. And even I have requested for unpaid leave. That also they haven't provided because I was sick. It's been almost a year that my hand is injured and they are not caring for that, then it's quite difficult for me to stay there. So I have given in written, but they haven't provided, so I had to leave. So they know, and they haven't denied anywhere that I was well.
You are only saying that the ITPB has not given you leave
Yes, Your Lordship.
for your treatment.
Yes, Your Lordship.
Does ITPB not have facilities to treat you?
Actually, they haven't provided. By what reason I don't know,
Whether
but
they have facilities, I think they have it's a very big, this force.
Your Lordship,
So they
it's
must have all this medical facilities, all these medical institutions.
Your Lordship.
to
Yeah,
treat
that's
their
why
personals.
I was posted in Dirang. Their facilities are not very good, but they have sent me in Guwahati. But I don't know by what reason they haven't provided that facilities to me. I don't understand, and so at last I have to leave from the Dirang unit for my treatment by myself.
That is the whole issue. See, you have left without informing the
Yes,
authorities.
I have
Oh, yeah.
informed, but they haven't provided me the leave, so that's the issue.
You have not sought for leave.
Your Lordship.
You have left without informing the authority.
I informed, but they haven't provided. It was difficult for me to stay there because of my hand. So,
Where is the documents to show that you have sought permission?
Your Lordship, it's not. At that time, they haven't granted me the.
Where's the permission? At least to show that you have actually sought permission and the authorities have not granted you. At least to satisfy that. Where is your permission? Application. seeking
After
for
termination, I have given.
Not after termination. During your treatment.
After termination, I have given, but during treatment also I have given, but that is before when I was there, when I was going through the treatment. But while on the day I was leaving, I have given, but they haven't accepted. So, and I was not in that condition that I can think that long, and I was very young at that time. So it was not in my mind that I can do anything for that. So I left. But later when police came, then he thought that I thought that the police will inform them because
I will listen to you, and if the facts are not satisfying, I may not hear you.
then I will argue on my provisions.
No provision, you first satisfy me on facts. Because provision comes only after the facts.
Because here is the violation of natural justice. I guess natural justice is more important than the facts. Sometimes
No, madam. You have not sought any information, you have not sought any permission, you have gone on your own. Where is the question of natural justice?
Your Lordship, if
Natural justice will come if you're on the right side. But you cannot take the plea of natural justice when you are on the wrong side.
then Your Lordship, if authorities are in wrong side and I'm also in wrong side, then who will win?
You have not sought permission to go for treatment. That's why I'm asking you, at least satisfy me with the application.
But Your Lordship, I have the medical documents. That I guess that will be satisfied.
See, when you are in a discipline force without permission, you go here treat, you go there treat. Whether that will be permissible? If on the facts, if I'm satisfied that I may not give you any relief, I may not hear you. I don't want to pass any adverse orders against anyone.
Then I may read these impugn orders, then I may place some judgments. After that, it's on Your Lordship.
You first, before going to the impugn order, you first satisfy me on the facts.
That's Your Lordship. He at that time he couldn't.
I'm asking you
Yes,
whether you have sought permission for your treatment.
Then Your Lordship, I may seek some time for going through.
You are actually trying to save a person. Come well prepared.
Yes, Your Lordship.
You are trying to save a person.
Yes.
We will encourage you, of course. We will encourage you.
Yes, Your Lordship.
But come prepared. Because the first point is whether you have sought permission.
Yes, Your Lordship.
From the authorities to go for treatment. Your treatment is a different issue. See, your treatment is a different issue.
Yes.
You may have been treated at Delhi, at Vellore, everybody, but the issue is the punchline is whether you have sought permission.
Yes, sir.
If without permission you have gone for treatment, I think something is wrong there. We give you time, come prepared, come
Yes.
prepared. On the prayer of Ms. So-and-so, learned counsel for the petitioner. Listed again after 3 weeks. Yes. Mr. M. Kato, please don't try to defend your client, try to help her out.
That's not my time again.
Try to help her out.
Madam,
You're a senior a professional, so try to help her out. Don't always try to get your victory by winning the case. Try to help her. Okay, at least. Yes, please. Okay, thank you.
by